But what's good for the goose is good for the gander, Your Honor. If they want to have the opportunity to claw back documents, the state needs to have the opportunity to.
Please, on the record, in case number 886110, can I, State of Nevada versus Meta Platforms, Messenger, Instagram, consolidated cases for certain purposes. Counsel, would you like to make your appearance on behalf of the state of Nevada, please?
Good morning, Your Honor. Chris Turtzo on behalf of the state of Nevada. Along with me here in court is Samantha Feely from the Nevada AG's office, Richard Hyde from the law firm of Claggett and Sykes, and observing over Zoom, I believe we have Mark Kruger from the Nevada Attorney General's office, Anthony Walsh and Raquel Fulgham as well, and from the Nottawache Law Group, Phil Carlson, Matt Bush, looks like Dory Tessler, and then Christian Barton from my office, maybe some other folks, but they'll all be observing only and not making appearances to argue, Your Honor.
Appreciate it. Thanks. On behalf of defendants.
Good morning, Your Honor. Tammy Peterson on behalf of Meta with me this morning. Arguing is David Sneed, who's admitted pro hoc vice. Also present in court this morning on behalf of Meta is Dan Polsenberg and Dan Wade, both from Womble Bond Dickinson. We also have some people observing as well who are not making appearances this morning. And they've entered their names in the chat, but I can just identify a couple of them: Zora Franasevic, Patrick Nutter, CC Bobbitt, Julie Meyer, and Ben Woodring.
Okay, thank you very much. Okay, what we have today is we have plaintiff's motion for reconsideration of order granting Meta Platform Inc.'s motion for stay of proceedings pending resolution of petitions for writs of mandamus. Applies to all cases. Document 368, Meta Platform Inc. and Instagram LLC's opposition, document 375. Plaintiff's reply, document 376, all timely filed. So we've got a couple ways to do that. I can tell you in advance that I'm anticipating I have 3 questions. I can let you know those questions up front, or I can wait until you've concluded with your arguments and ask you at the end. The court has no preference. What would you all like?
For Chris Turtzo for the state, Your Honor, given I think it's a pretty detailed briefing on file already, I'd like to hear the court's questions and focus on those rather than rehash arguments that I think are present in some very detailed, nice briefs.
Meta agrees with that. We'd like to hear the court's questions.
Okay, sure. Okay, so the 3 questions are, first, in the briefing, there was some argument about things that were stated to the appellate courts. So my question would be each party's position, whether I can or cannot consider those. And second part B of that is, and if I can consider it, what weight is each side contending the court should be taking that into account? Second question is, and the opposition was on behalf of 2 of the defendants, and there's a distinction apparently made with regards to the messenger aspect. So how, in light of the parties' prior stipulation that these were to be all cases, are the parties stating that the court should be addressing that issue? Meaning, is there a distinction with messenger, or should be taken a bit differently? Somebody else is coming in. Do you want me to pause for a second? Is that with you all? Oh, it is. No worries. Would you like to make your appearance or just observing?
Primarily observing judge, but I'll go ahead and put my points in the record. William Sykes, counsel from Claggett and Sykes Law Firm on behalf of the state.
Appreciate it. Thanks so much. Okay, so that was the 2. And then the third. The third is, this relates to a question I had asked at a prior hearing, is how should this court take into account from each party's position the fact that the Nevada Supreme Court in this case, right, sua sponte, granted en banc reconsideration approximately 7 months after the decision, right? And how that would apply to the state, meaning is that some indication to the court that they are directing a district court not to address this issue because they want to address the issue, right, as it applies to a stay. Okay, so those would have been courts. I'm anticipating 3 questions. Does anyone have any questions on my questions? No?
None from the state, Your Honor.
Just so I understand the second one, you noted the opposition is only on behalf of Instagram and Facebook and not on behalf of Messenger as well? Is that?
There's a different argument made with regards to Messenger, okay? If you look at your document filed on 12/10/2025, Meta Platform Inc. and Instagram LLC's opposition to plaintiff state of Nevada's motion for reconsideration of order granting Meta Platforms motion for stay of proceedings pending resolution of petitions for writ of mandamus is the way that document was titled.
Yes, Your Honor.
And it appears, right, in the pleadings that there's some distinctions being made between the Messenger case versus potentially those other two, or maybe not. That's why I was asking the questions, just to get a little bit of clarity in light of the parties' prior agreement on how this court was supposed to treat these cases, right, in a more combined fashion. If it's a distinction here for this one that is being asked, I need to have a little bit more understanding of what's the position. And when it gets to be your turn, feel free if you want to address that.
Yes, Your Honor. I'll
Okay,
address
appreciate
that
it.
when
Does
it's
that
my turn.
clarify your question?
It does.
Okay,
It does.
thanks so much. Okay. Counsel for the movement, go ahead, please.
Thank you, Your Honor. Chris Turtzo again for the state, turning first to the court's first question about can this court consider the statements made to the appellate courts, and if so, what way? If I'm understanding the court's question there, the first question, right?
Sure, each party's position, whether I should or should not, whether I can or cannot, how we'd like to phrase it, and if so, to what level. Go ahead.
I think from the state's perspective, we certainly believe the court can. Obviously, the statements that Meta has made throughout the call it the writ process are relied on heavily throughout the state's papers, including the en banc reconsideration. For example, as the state has pointed out in its papers, Meta argued to the Nevada Supreme Court in order to get that en banc reconsideration that was granted 7 months down the road, that there was a need for decisional uniformity. Meta argued that the issues were that the cases that Meta's positions raised that the cases were nearly identical. The case brought against Meta by the state as the case brought by the state against TikTok and Snap. Meta also said that the constitutional and statutory arguments that Meta raised were essentially identical. And you know, why is that important? And I think, again, I think the court can rely on it because really at its core, this request for stay is an equitable consideration. Fritz Hansen talks about granting a stay where the equities dictate it. And in considering that, I think the court is able to and should look at the totality of the circumstances before. And in this case, the one against Meta in particular has a longer, more, I guess, complex history than perhaps TikTok and Snapchat, in part due to the preliminary injunction motion and the fact that the original writs were denied. But I think considering the equitable remedy that Meta has come to this court and sought in terms of a stay of the discovery in this action, the statements that it's made are, I don't want to say they're necessarily binding admissions, but they're highly relevant to the question of what is the impact of the TikTok decision on this case. And the state recognizes that the court's order granting Meta stay did take TikTok into account, but the party's briefing didn't obviously have the benefit of the TikTok opinion, and we didn't have the benefit when we argued it. And as the state's pointed out, we think an analysis of the TikTok opinion demonstrates that ultimately Meta's not going to win on its writ petition, that the novel legal questions have been resolved, right? The court stayed this case despite finding that the state was the one, that Meta wasn't likely to prevail on the merits, but that the issue that this case raised novel and complex questions. And that was one of the factors that supported a stay. From the state's perspective, Meta has admitted in its writ proceedings that those novel issues are identical to the ones presented in TikTok, and they've been resolved. For example, the question of, can a worldwide social media company be subject to personal jurisdiction in Nevada based on things like marketing to the state, collecting data in the state? And the TikTok opinion answers that yes. The Nevada Supreme Court relies on Briskin, it relies on Ford Motor in establishing generally the standard for imposing personal jurisdiction on a worldwide social media company. Same with the analysis of on 230 and First Amendment. And again, Meta said these constitutional and statutory issues are nearly identical. And so we believe from the state that the court needs to take that into account in evaluating whether this case should remain state in light of TikTok, and we believe that it shouldn't. If the court has any more questions on that first court question, that's all the state has to ask. Number two, on the messenger aspect, I don't know that I can speak to that right now for the state. I'm not quite sure why the pleading, the opposition just references Meta and Instagram's opposition. I know there are some differences with Messenger. The one thing I want to point out is the only defendant where the opposition papers try and distinguish TikTok in any meaningful way is with respect to Messenger. But again, I'm not really sure why it doesn't, what the choice is there. So I just reserve on the answer to that question after hearing more from Meta's counsel. The last question the court asked was en banc reconsideration 7 months after decision. And what does that mean here? I don't know. Frankly, Your Honor, I don't know. And I think in this situation, Your Honor, given what we have, and I don't want to spend a lot of time on going through the new evidence as the state lays it out in its brief. I think we've done a really good job laying it out. I think we've pointed out exactly what the harm to the state is and why it's relevant and why a stay shouldn't be granted here. The state wants to immediately get into discovery regarding these claimed clawbacks, which continue to come, by the way. You can set your watch by the Friday night clawback letter that Meta sends every week, Friday night. Those clawbacks are still coming, and Meta's taking the position that it's going to continue to claw back documents, but the state can't challenge the clawbacks unless and until the stay is resolved. And these are things that, given the testimony that was presented to Congress, given the facts at issue in the DC order, and we recognize there's reconsiderations granted, but given the court findings that these clawbacks, at least 4 of them, were not appropriate because the attorney-client advice there was potentially in furtherance of crime fraud, and then also the deposition testimony, which we submitted under seal, and I'm not going to quote directly for that reason, but we believe clearly corroborates the new evidence here. If Meta wants to obtain a continued stay in light of TikTok, they can petition the Supreme Court for it. And if the Supreme Court decides, they're the only ones that know why they proceeded the way they did with respect to Meta. But if it's not as if Meta loses a remedy, if they lose the stay today. We don't know why exactly it took 7 months to order en banc reconsideration. It would certainly suggest that the Supreme Court recognizes that there were related questions in all 3 writ petitions. They decided to answer TikTok first. But if Meta wants to have a stay, particularly in light of the new evidence the state's provided, which again, we think raises very serious questions that ought to be discovered and addressed now, Meta can petition that from the Supreme Court. With that, Your Honor, unless you have further questions, given the court's prior instruction about the time for this hearing, I'd reserve for rebuttal.
Okay. Can you just clarify what you meant by the last sentence? Raises questions. We referencing the discovery raises questions that you want to go, the clawback or something?
The clawbacks,
Okay.
correct, Your Honor. The clawbacks and the privilege claims, and also the new evidence that, and by new evidence, what I mean is the 3 pieces of evidence the state cited in its motion. These things raise significant questions in the state's mind that we believe equity compels the state have the opportunity to discover and address now rather than wait subject to stay.
So earlier in your argument, you made a reference to the clawbacks. Okay,
Yes.
you said at the end as well. Are you contending that Meta, and I'm using Meta in the general sense until I hear a clarification that it should be something more narrowly tailored, right, to two, not all three. That Meta is engaging in litigation, but yet the state is precluded from doing so by the stay, or are you saying it's happening in a different jurisdiction, which raises issues that you want to pursue here? I'm just trying to get the understanding
Understood.
whether it impacts here or not, or it's just in DC.
Yes, and I'm happy to clarify that. So Meta is issuing clawbacks to the state in this case. Meta's produced, I believe the count is 2.5 million documents, pages. Meta's produced a ton of material to the state. Meta has issued, since the stay was entered in this case, Meta has issued several clawback notices to the state in this case, asking the state to sequester documents and indicating replacement materials will be provided. And the parties had some meet and confer correspondence on this, which is attached as, I believe, Exhibit 7 to the state's motion. But Meta's position is the state can't challenge the clawback. So Meta can claw back documents in this case, but the state can't challenge them. And I want to be fair to Meta, Judge. I recognize they have to do something, right? If they wait, the longer they wait, if there's a document they contend is privileged before clawing it back, that puts them in a bit of a bind. But what's good for the goose is good for the gander, Your Honor. If they want to have the opportunity to claw back documents, the state needs to have the opportunity to challenge those clawbacks now before these issues get stale. And again, it demonstrates that equity doesn't favor a stay because there's ongoing issues. Meta is again, the DC order dealt with a clawback, right? Meta tried to claw back documents in DC. That clawback was challenged, and the court said, no, you can't claw back those documents. There's the attorney-client privilege that's being asserted as the basis for the clawback doesn't apply because it appeared to the court in that case that the attorney-client advice was given in furtherance of crime, fraud, or helping Meta avoid downside risk in litigation. And from the state's perspective, that's been corroborated. That behavior has been corroborated by two independent witnesses. So the state believes that these things raise very significant questions. And now, as Meta's clawing back documents now, the state can't challenge those clawbacks. At least not now. And the state believes we ought to be able to, particularly again, because the writ that Meta has previously admitted raised nearly identical issues has been resolved. Those issues, those key novel legal issues have been resolved by an en banc Supreme Court published opinion that Meta has previously said is essentially on all fours with their petition.
So are you seeking as an alternative position, a carve out of the stay, if the stay is not completely lifted, to reconsider to do a carve out to address the clawback issue? Or are you requesting reconsideration of the stay in its entirety? So I just need to know, is there two options you're asking the court to rule on, or one?
We're requesting reconsideration in its entirety based on what the state characterizes as intervening change in the law and the totality of the circumstances. That said, if the opportunity is there to address the clawbacks, I believe, we can confer with the state, I believe we'd rather have that option than be stuck waiting for a ruling from the Nevada Supreme Court because of the seriousness with which we ascribe to these clawback issues. So if it's between that and remaining state, I'd presume the state would like the opportunity to challenge the clawbacks and litigate those issues now.
Appreciate it. Thanks
Thank
very
you, Your
much.
Honor.
Hey, counsel or Meta.
Good morning, Your Honor. David Sneed on behalf of Meta. I want to start with the questions that the court asked up front as to the argument relating to this reconsideration motion that's been filed by the state of this court's decision to stay this case pending the currently ongoing appeal before the Nevada Supreme Court. The first is whether this court could consider things that were stated to appellate courts and what weight the court should offer to it. I don't think that there's a basis for this court not to consider or not to be aware of the statements that were made to the appellate court, but I don't think that any of the statements that have been relied upon by the state bear on ultimately or support reconsidering the stay. And I say that because as many times as council said in our petitions, we said that things were very similar, the legal issues were very similar. I think there's a difference between saying there should be reconsideration of the decision that was made because there are similarities between what you're considering right now in TikTok, and saying the court's application, the Nevada Supreme Court's application of the law to those facts are on all fours entirely. Meta has not said and did not say that the decision that was made in TikTok is going to control all the things that are going to happen in the Meta cases for any of the three cases. And if the court would like to consider statements made to appellate courts, the state has not mentioned the briefs that have gone in very recently to complete the briefing before the appellate court that explains in detail why the TikTok decision does not control what's going to happen in any of the meta cases. And the reason for that is a couple different items. The focus in the district court's decision on Facebook and Instagram, availability to Nevada users to find personal jurisdiction is not something that was done with the TikTok case. And the allegations that supported the finding of jurisdiction in the TikTok case were different. Informed marketing efforts, such as outdoor advertising and billboards, it means there's something different about the application of the facts that mean that these are different cases. And I think each one of the cases require an individualized assessment on the facts. So just because there is a similar legal issue, I wouldn't say that there is a hugely dissimilar legal issue about the First Amendment or Section 230. There is a legal issue that's similar between the cases. But the court is being called on to decide different cases. And in our appellate briefing, we've explained how different those cases are and why we think that notwithstanding what the court did in TikTok, the court should consider the meta cases differently. And this court was already aware of the TikTok decision and included the TikTok decision in the court's decision in the motion to stay originally, the stay decision originally. And that's an indication that there has been, and the state can point to, under the reconsideration rules in Nevada, a change, an intervening change in law. There's been none. There's been nothing that has been different between the time that the court considered this issue and made its decision and now. All that is different that the state wants to point to is one part of an earlier brief without consideration of any of the other briefs that describe in detail why this is a different decision. So that's my answer on the first question. If the court would like to be provided other materials related to the appellate briefing to consider the other statements that have been made around the differences between the case, you can, but we don't even think that's necessary because what the court stated in the decision on this motion to begin with was accurate and explained why it didn't control. Now, on the second issue, whether there was argument in the opposition on behalf of only two of like Facebook and Instagram and not Messenger, I think my understanding of the part of the opposition that you're referring to might be in relation to our arguments on the point I was making about personal jurisdiction and the issues that were there.
Just to be clear, the reason why I'm interrupting you,
Sorry.
I read from your caption of the opposition.
Oh.
That's what I was reading from. The caption in the opposition said it was only on behalf of two of the three parties, which implicated the EDCR 2.20 issue, that you did not oppose it on behalf of Messenger. It's really, right, if that was the intention. So once again, I was looking at the caption now in the body, okay? Because
But they were renamed across, but it's only the two parties.
Right, I see.
right, in the body, you address something a little bit different. That's why the court was asking the question, because in reading through this, I look first to see, right, who on behalf of something's filed, right? To give the scope, and then I look at the body of all the supporting information and to see what is done. So it was just a little
I
unclear.
understand. There is no entity that is Messenger as an entity that's the defendant. Meta and Facebook, and formerly known as Facebook, so that's Instagram. These are all the parties. So the caption captures the defendants that cover all three cases. If that makes sense. There's only two parties. There's not a third party. And we include Messenger in as a part of Meta. It's not a distinct party like Facebook or Instagram is referenced in the caption.
Take a look at your caption
Yes.
on this opposition. Do you see what the caption? State of Nevada plaintiff versus Meta Platform Inc., FKA, Facebook Inc., comma defendant. Second one says State of Nevada plaintiff versus Meta Platforms Inc., FKA, Facebook Inc., right?
Yes.
And then State of Nevada versus Meta Platforms Inc., FKA, Facebook, comma, Instagram LLC.
Right.
So they have distinct case numbers before they were consolidated. So that's why the court was asking the question, right? Because usually when you have distinct case numbers, right, you're making a distinction between a party's identity. Otherwise, you wouldn't have been able to file two separate case numbers against the same party with the exact same, right, information. Normally that would somehow get combined somewhere else. So these.
My understanding is that there were three separate complaints originally.
Right,
And
that's
the
what I was
parties
going,
that were sued were the parties that are listed here in the three separate complaints. I believe the first was in relation to Facebook. The second, I think, is in relation to Messenger, and the third is in relation to Instagram. And so just to step back, our opposition is on behalf of Meta in all of the cases. And we included argument related to Messenger because our intention was to ensure that this opposition functioned as our opposition for all three cases. And I didn't understand the state to be making an argument in the reply brief or making an argument here that we somehow waived the opportunity to oppose to Messenger. I think that despite the names of the parties being different, our opposition is in relation to all three cases that were there.
Appreciate it. Okay, thank you so much.
So I guess that resolves the second issue that you raised. I want to make sure to hit the third issue that you asked about. How should the court take into account the fact that the Nevada Supreme Court granted en banc reconsideration to the decision, and how does that apply to the stay? In my perspective, the basis for the stay is the ongoing and consideration of these issues with the Nevada Supreme Court. I think this is crucially important to this day. And in fact, I'd say that the decision from the Nevada Supreme Court to grant that and to take up these issues for Meta and to do them distinctly from how they did them with TikTok is the real foundation for why this court should hold on all proceedings until that's resolved. I think that trumps, in fact, I think that's so important that it trumps unrelated issues around privilege that can and may be litigated if this court proceeds, if this case proceeds past the appellate decision. But I think that decision is more important than any of the issues that's been raised in terms of reconsideration, and significantly, none of the issues related to reconsideration get at any of the issues that the appeal is currently on. The issues that they're raising don't provide a basis to say that somehow the Nevada Supreme Court is not considering or should not be considering all the issues. Instead, they're raising essentially discovery issues, which can be taken up after the stay is lifted, if it is lifted, if we lose with the appellate court. And that's the reason that the stated reason for the stay is really the appellate decision-making ongoing. I did also want to quickly address the clawback issue. And the state is correct that we have provided certain clawbacks of materials. And the reason that we have sent clawback letters at this time is because we did not want to be in a position where it was stated that we waived the ability to preserve the ability for us to claw back information that we believe, after looking at the document, we believed was privileged. And so we moved quickly. We moved expeditiously to be able to do that. We wanted to avoid any indication that there would be waiver. We don't think it makes sense for there to be any carve out or any exception to the current stay on the basis of the clawbacks, because the reason for the stay is the immunity issues and the issues that are dispositive in this case, such that Meta should not be obligated to continue litigating the case when the Nevada Supreme Court is currently deciding whether the case should even be here. It's a fundamental jurisdictional question that overwhelms and takes preeminence over issues related to privilege and discovery that the parties can take up. And when asked, the state hasn't offered any reason why, if the case comes back, there's any reason that it has to be done now. There was a statement about the fact or idea that there's something that's going to be stale. No, discovery is going to be ongoing if the case comes back, and there will be plenty of time to be able to litigate whatever issues need to be litigated with regard to privilege, and any other issues relating to discovery. And we are happy to do so if the case comes back, and we will address that at that time. But during the course of the stay, a stay that's been done for jurisdictional questions that are being considered by the Nevada Supreme Court, there's no reason to carve out and say, and there's no basis in the law to accept out discovery and say that can go on when the basis for the stay is jurisdictional in that fashion.
Counsel, can you provide me some support for that last sentence that you just said? That there's no base, and I'm not really asking you to prove a negative, right? But if you're saying that some Nevada Supreme Court or Nevada Appellate Court case has said that you can't do a carve out and a stay, just FYI. Remember TikTok was before this court, so in TikTok, they did ask for a more narrow stay from this court. And so, not that I'm raising TikTok, you all keep on mentioning TikTok. I'm not saying TikTok's role in this case, right? But from a pure factual standpoint, TikTok's request for a stay to this court was more narrow than what's being asked before this court. So I am hearing different positions as to whether or not there can be carve-outs and a more narrow stay. And so if you're contending that it has to be as to everything under Nevada law, is there some support for that proposition?
Well, let me say it like this. No, I am not referring to a Nevada Supreme Court decision. I think to clarify what I meant by that is given the stated basis for the stay in this case, our position is that it would be inconsistent to allow further proceedings in the district court at this juncture when the reason for the stay that's been kind of established is the ongoing appellate proceedings that will resolve really fundamental and jurisdictional issues in the case. And there's no need that the state has given for any urgency or any statement of prejudice that would occur to the state in relationship to this issue being litigated at a time when the case, if it comes back, is back. The only thing that was stated in the briefing was a repeated allegation that somehow allowing there to be this interval of time to the extent the case comes back would allow Meta for some reason to destroy evidence, when in fact there is nothing in the record that says, there's no court finding that says Meta has destroyed evidence, and Meta has no intention of not taking its preservation obligations very seriously. The only thing that they have been pointing to in the record has been a question around privilege, and the issue is not about, and I want to be clear, there was indication that crime or fraud was the basis. The basis was not crime or fraud, it was other misconduct under that state's regime. And that currently is under reconsideration, and the court decided to stay the order because there was good cause to do so when looking at a probable cause finding around what happened there. That is a very specific issue related to privilege. And if the state wants to have that issue litigated, we, at the time that this case, if it comes back, we are prepared to do so and litigate that accordingly. But I think my point overall was it would be, in Meta's position, inconsistent with the stated basis for the stay to allow a carve out for litigation around these clawbacks. And this is a nationwide, this is a litigation that's going on. Meta is not specifically clawing back documents just in this matter. Nationwide, at the time that Meta realizes that there is an issue or an issue that needs to be clawed back, Meta provides that clawback in all the jurisdictions at the time that we identify that. And so we're trying to be upfront and direct and expeditious in terms of our obligations, but that does not mean that the litigation around the challenges related to it has to happen immediately. And I don't think there's a reason for it to do so here. Unless the court has other questions around that, I think I will just say,
I do.
uh,
Way I was understanding what the state was asking the court to do is the state was saying that the state of Nevada, unlike other locations, they use Washington DC, right, is able to respond to these clawbacks, and that the state of Nevada, I understood that they were basically asking this court in part to reevaluate the Fritz Hansen prong with regards to irreparable harm to the state and evaluate it in light of what they were contending was new evidence of the clawback and then their inability to be able to respond to that, whereas regardless if it's happening around the country or not, but that they don't have that, so that Meta is affirmatively taking some actions during the stay, and the court's not taking a position whether it should or shouldn't, that's not before me, but that Meta is being able to take some actions during the stay, but yet the state is not being able to, and that means I should reevaluate it for new facts and evidence under a reconsideration standard and reevaluate the irreparable harm prong. That's the way this court understood the request from the state. I didn't see that they were saying that you all were engaging in inappropriate conduct, but they were utilizing it in the reconsideration context. So are you contending that that's not new facts that would be a prong for the court to evaluate a motion for reconsideration, at least in part?
No, Your Honor, I don't think the clawbacks are necessarily new facts that would justify reconsideration, or I haven't seen any authority that's been given that the fact of a clawback justifies some kind of reconsideration of a discovery stay. I think the particular provision you're talking about is irreparable injury and harm, and the consideration of whether the state is irreparably harmed or there's some harm that comes to the state. I don't think the fact of the clawback itself and any of the purported new evidence that they've pointed to justify it, because I don't think that there is actual harm to the state when discovery is stayed, and there's nothing that is happening in the case such that that this issue, to the extent it needs to be litigated, it may not need to be litigated entirely because of the jurisdictional issues that are pending before the appellate court, and if it does, there is really no difference between litigating it now or litigating it at the time that the stay is lifted if it comes back. The idea that something is stale, it doesn't really change anything. And there is no actual finding at any stage that anything has been destroyed. And so the allegation or the speculation that something is destroyed shouldn't justify under NARP 8C the finding of irreparable harm. To the contrary, the injury to Meta in continuing to litigate claims that in our position should be dismissed and we have immunity from, I think weighs in favor of Meta on that prong. And so what the state has brought forward doesn't justify a changing of the weighing by this court of that prong. To the contrary, in the record in the DC order, what we have is actual and I think this is a part of the record in this case. I'm not going to go into detail about sealed items, but the record in that case reflects that neither the court stated that there was a finding of spoliation or destruction, and the witnesses there had not provided the declarations that have been provided by the people that were involved in the very documents that are being raised, have not given any indication and had not stated anything about destruction of documents, such that the basis that the state offers, which is that more things will be destroyed, changes the weighing of 8C in this case.
Cool. Thank you very much.
Thank you, Your Honor.
Okay, counsel for the state, you get last word. Go ahead, please.
Thank you, Your Honor. I want to stay on that point, Your Honor, about the harm that may be imposed by continued stay. It's not just about clawbacks, Your Honor. I want to make clear, Sadazan's a whistleblower. This is a person who's just testified in front of Congress in September. This is a whistleblower who testified about legal interference with his work and research when he worked at Meta. Page 15 of the brief, we quote some of his testimony where he says, "I want to be clear. I was threatened by lawyers. Going on to page 16 of of the state's opening brief, he says they threatened our jobs. The stay, in addition to precluding the state from challenging what the state believes are potentially improper, repeated clawbacks, also prevents the state from doing any discovery, potentially on an expedited basis, on some of these whistleblower allegations. Maybe the state would try and take an early deposition. I'm not sure what exactly we'd want to do, Your Honor, but it's not just about clawbacks. We have active whistleblowers here who the state can't talk to in a formal discovery way. We can't subpoena them. This is testimony that just happened on the 9th, and Meta's opposition was critical. We didn't raise it sooner. I think that was the day before we filed our opposition. This is stuff that has just come out. And further, it's now looking more like a pattern, right? We have Sadazan testifies in early September about legal interference with his research activities when he was at Meta. And to be clear, this isn't overall research. This is legal interference with Meta's research regarding the harms its products caused children. And he said that legal interfered with that. Then about 6 weeks later, a court in DC denies an attempt to claw back documents because the alleged attorney-client privilege there didn't apply because of DC's, the District of Columbia's crime fraud exception. And then further, once the state began reviewing the deposition transcripts that we got on September 25th, I believe, just when the stay was being argued, there's deposition testimony that corroborates a pattern of legal interference. The state's not allowed to do any of those things. Meanwhile, Meta continues to close ranks in the Nevada case and try and build up the defenses that it's going to assert in response to these claims, including clawing back more documents it claims are privileged, even though they produced them. And so they're continuing to develop their defenses to these very important claims, and the state's precluded from doing anything about it because of the stay. And why? Again, counsel stood up and said the reason we need the stay is the pending appellate, the writ proceedings. Well, to quote from the TikTok conclusion, Your Honor, the district court properly exercised specific personal jurisdiction over TikTok because the state's NDPA claims target TikTok's alleged misrepresentations and unconscionable design elements that addict Nevada's young users to the TikTok platform. Sounds very similar to the basis for the court's finding of specific personal jurisdiction over Meta. The Supreme Court further goes on in TikTok. Those claims sufficiently relate to TikTok's purposeful Nevada context in collecting young users' personal data and selling it to advertisers targeting those Nevada users, thus satisfying due process. In reaching that holding, the Nevada Supreme Court brings Briskin and Ford Motor Company to Nevada. Again, that's the same legal, the novel legal question at issue in the personal jurisdiction here. The 230 and First Amendment claims are the same. The district court properly denied the motion to dismiss because CDA section 230 and the First Amendment do not protect TikTok from liability for its own allegedly misleading statements and omissions about safety risks to young users or for allegedly harmful design features that are not based on third-party content or its own expressive activity. Again, that's this case, Your Honor. If Meta wants a stay in light of the evidence the state has set forth, and in light of the fact that Meta is continuing to take actions to claw back documents, Meta ought to get that stay from the Nevada Supreme Court. And I think based on all that, this court should reconsider its order staying in this case.
Appreciate it. Thank you so much, everyone. Thanks for the excellent briefing and the excellent oral argument. Okay, here's where the court's ruling is going to be. We have before the court is a motion for reconsideration. As you know, that does anyone want me to walk through each of the factors on a motion for reconsideration, or can I just say incorporate the pleadings, the case law and the pleadings?
Case law and pleadings is fine for the state's purpose, Your Honor.
It's fine for Meta as well.
Okay, so what I'm looking at is realistically, I'm going to grant reconsideration in part, and here's the court's analysis, the reason why. There were 4 different aspects that were asked the reconsideration. The first one was there is an intervening change in controlling law. That is one of the standards with regards to a motion for reconsideration. And there in support, it was basically saying that the TikTok case, 141 Nevada Advanced Op 51, which this court is very familiar with, dispense of any serious or novel legal issues. The court doesn't find that that would be a basis for reconsideration because the TikTok decision, the Supreme Court didn't say it applied to any other case or any other scenario. This court did evaluate TikTok, as you saw in the minute order that then was incorporated into a written order, and looked at every word. Look at it for 2 different reasons, for this case and since I have the TikTok case. But I looked at every word to see what that was, and I did not see that it made the decisions in this case moot. I did not find, it's up to the Nevada Supreme Court to make its own determination for each of the cases before it. If it had wanted to do this case first, it could have. I don't read any tea leaves in that regard, but I have to take the fact that it said what it said in TikTok. It applies to TikTok, but I do not see that it said a broad reaching analysis that this would apply to all social media companies or something, or that they specifically mentioned Meta, Messenger, or Instagram. And so I have to take it on its plain reading, and therefore I do not see that there's intervening change in controlling law. The second prong, state has obtained new evidence of Meta's serious misconduct, and then there's examples. Here, the court does find why I need to grant partial reconsideration. And I'm not treating it as misconduct. What I'm treating as new facts. The new facts is one of the standards on a motion for reconsideration. The new fact about the issue of ongoing clawbacks, which means, and I'm not stating that Meta is doing anything inappropriate by doing clawbacks. That issue has not been before the court. I take no position on it. But the fact that Meta is engaging in litigation conduct by seeking the clawbacks for whatever reason, while I understand why they would do it for waiver, etc., not, once again, not making any advanced rulings, the state's being precluded from doing so. So that means this court has to reevaluate. That is a new fact that's presented to this court. Then I have to evaluate it on the various prongs under Fritz, Hansen, and Micon. Prong 3, the third factor is what I had ruled in the prior decision, is that the third factor had favored defendants, the alleged harm to the state if a stay is granted. And the court's analysis then was based on what was the information provided to the court at the time I issued the stay. And I'll read in part the paragraph, there's more, but I'll read in part. Well, the court has said that in essence, the state's argument is focused on alleged irreparable harm to Nevada customers who use Meta platforms. While the court acknowledges the importance of the state's interest in protecting Nevadans, the court has to consider any alleged harm to the state. Defendants argue the state is really complaining about the delay in pursuing discovery and its litigation goals, which does not constitute irreparable harm under Hansen and Micon Gaming, and that the status of alleged harms may have changed. Okay. So the court then said, and I gave more analysis and more examples, and then they said the state has not met its burden to show how a stay would cause harm, much less irreparable harm, to it in light of the applicable case law if the stay were granted. The state's various actions since March 2024 do not support its new claim of urgency. As a result, the court finds that consideration of this third factor favors Meta. Well, now I have new facts. I have new facts that there is something that is currently ongoing. Taking no position on the clawbacks because I haven't heard anything about them, okay, other than some argument today. But that is new facts. That's new litigation. Having the state being precluded from its ability to respond to that, I do find could potentially be irreparable harm that this court should at least evaluate, which means it's a new fact, which means I have to reevaluate that third factor with regards to the alleged harm to defendants. And in reevaluating that third factor means I have to do a carve out of the stay with regards to the clawbacks. And we'll get a little bit clarity of what everyone means by clawbacks in just a moment. Okay. So with regards to the whistleblower asserted of the hidden harms examining whistleblower allegations, the subcommittee issue, the court doesn't find that that would be a new irreparable harm to the state because you already have whatever that testimony is, it's already memorialized. The ability to take depositions, no one's telling me that this individual, hopefully this doesn't apply to the individual, that they're ill or something, that there's some urgency, okay? It's just, it's an individual whose deposition the state would like to take, but there's nothing that's presented to this court that there's some irreparable harm with regards to having a stay that somehow would preclude that testimony, particularly since the testimony's already memorialized and further inquiry into it can happen during normal litigation. So I looked at that factor as well. So then I go to 3, Meta's request, the court erred in its application of NRAP 8, specifically the failure to conclude that Meta carried its burden to show the balance of equities weighs heavily in favor of granting the stay. Well, court had thought it was pretty clear, saying that the failure that the burden of balancing the equities weighs heavily in favor of granting the stay. I did cite Fritz Hansen. I thought the analysis stated that. If it didn't say it specifically with those words, I'm saying it now. That did with the subject to the carve out for today. So the court doesn't find that there's an error law. That's number 3. And so therefore, and whether you take TikTok in a different context as far as new facts separate and apart from what the court already said from the legal standpoint, that was the 4th prong. I don't see that TikTok brought new facts, and see my analysis on the legal conclusion on TikTok. So based on what has been presented to this court on this motion for reconsideration, the court does find that it needs to grant reconsideration in part and do a carve out to the stay to allow the state to respond to what I'm going to call, what you all have called actually, the clawback issue. Now, does somebody want to clarify what you mean by the clawback issue so that at least it would minimize if there's down the road about whether something can properly come before the court as quote a clawback issue? If not, I'm going to use the term clawback issue and let you all work it out down the road. But if somebody wants some clarity now as far as the scope of that, please let the court know so we can kind of have some type of agreement that can be memorialized in the order.
Do you want to go first or?
Yeah, I'll go first. Chris Turtzo again for the state. I anticipate we may have to have some discussion with Meta, maybe fruitful in framing exactly what the court's order would look like. Generally, I think the state would like the opportunity to challenge clawbacks issued by Meta, whether that be through the special master and through the court via the process that's currently in place. That's generally what I think the state would like the opportunity to do when we say the clawback issue. If we get a notice and we want to challenge it, we'd like to be able to litigate those challenges through to conclusion. But again, as we've been able to do throughout, we're also open to speaking with Meta to frame the exact logistics of the relief.
I can say on behalf of Meta, our position would be in terms of clawbacks, what happens factually is we send a letter to the state that describes what we're asking to claw back. And then in our position, our position on what we think might make sense in this scenario is the state would be able to send back a letter saying, we challenge that clawback. We could understand if perhaps there could be a meet and confer that happens, but our position would be that there would be no need to ultimately litigate this to the court and have motion practice and litigation practice, but we would be able to allow the state to respond, give their position, and even meet and confer with the state about what their position would be. And then to the extent that the clawbacks collectively will be litigated, if we get the case back at the end in front of Your Honor or in front of the special master in the first instance. That's what we propose.
On the state, I think we ought to litigate them through to conclusion. One, because that's the only way that the issue is going to be resolved. If the state issues a challenge, they meet, confer, and they say, sorry, we disagree, doesn't do anything to mitigate the concern that the state's raised. Number 2, if it comes back, get this out of the way and have it done. If we're going to carve it out, let's carve it out and complete it. I don't see any harm to Meta from if the court's going to carve out resolving these clawback issues, we ought to carve them out all the way and allow the process to play out completely.
Say, let's set a deadline within 20 days of the stay being lifted. There can be a collective motion related to the clawbacks that have happened during the course of the stay. And then all things are addressed at one time in a very efficient way.
Well, let's walk through where the courts and sure. Remember, I do have people patiently waiting for their matters to be heard as well. let me tell you where the court's heading. I think I'm gonna hear from each of you all, but let me give you an idea where the court's heading, then you can give a response. The court's heading that you have 14 days under EDCR 7.21 anyway to get this court an order from today, that realistically, and you can do the math when that 14 days might happen, right? So if you're asking me for additional time, that I set a hearing the very first week in January, right? To address if you all have not come to a mutual agreement as to the scope of how the clawback should be in a proposed order, then I could hold a hearing in that regard, because let me be clear what the court's intention is. The court's intention is that I needed to reevaluate the court's prior order because of new facts, okay? I found that there was irreparable harm. I explained what the irreparable harm was, okay? Which modifies the analysis in the third section, starting on page 5 of the court's prior order, okay? Which means that this court, when I was using the word carve out, was intending that if there needs to be some conclusion, right, in order to have, not saying that there is or is not anything going on. I'm not, no way making any advanced judgments at all. But if somebody wants that issue addressed by a court, right, to ensure that maybe there's a court order one way or another, if necessary, if established, right? That process, that's why it would be the irreparable harm, right? So just unless you all agree to just letter writing back and forth, the idea, right, of irreparable harm is that the court would then need to intercede through the special master process. You all have specifically agreed, right? Unless you all stipulate that this would fall outside the special master, and then I would evaluate that, right? But that here you have a process in place to ensure that you can get resolution on specific issues that would be of a very timely nature. Not a great example for this particular case, because I was going to say, similar to injunctive relief, but in this particular case, the injunctive relief was a little bit different because of all the stipulations. So it doesn't specifically apply here, but it's that idea that you get quick access to the courts to resolve something that is saying irreparable harm, because it would not be, that would be consistent with the court's finding of its reevaluation of the third prong, finding that there would be irreparable harm is why I'm doing the carve out. Okay. So to say down the road would not be consistent unless the parties agree with what the court's intention is. I will tell you, I'm really also inclined to do a 30-day status, 30 or 45 days. We're going to hear a moment of what you all wanted on a status on the stay, and whether what is the current status, right? And what the court should address at that juncture. Because once again, I think that allows just an evaluation, right? It's a status, it's not a revisiting, it would be a status of like where things are. Okay. So that gives you at least a heads up, so we're clear where the court's inclination was and its analysis on why revisiting that prong, which then meant the carve out on the motion for reconsideration. Just to be clear, I reevaluated each of the prongs, but the other prongs I do not find get changed in any manner. I found that the third prong. Okay, so just in case it wasn't implicit of what I was saying, I'm explicitly saying, yes, I reevaluated everything. Everything else remains in full force and effect. It's just this is implicated by new facts. Okay. So in light of that, do you all want a week or two for me to set a new hearing date? What would you all like? Because I can tell you, as very sophisticated counsel, I can ask you if you want to go out in the hall and try and resolve it right now, and I call other cases in the intervening time because of everyone who's patiently waiting. Or if you think that you need more time because you've got people remotely and a variety of different people that you might want to consult with, we can revisit this issue if I don't get an agreed upon consensus in a proposed order. What do you all want?
From the state's perspective, I think we can rather take some time, confer on our side, confer with Meta, and see what we can resolve in the orders. Hopefully we could reach a joint one and submit it.
Well, one of you has already specifically asked me not to move a hearing that was set for December 31st, and specifically stated that they wanted to be here.
It's not me, sadly.
Oh, wait. Counsel, aren't you here on the 31st? Were you? No, I may be incorrect, but
Hope not.
it was on the state side. I thought, 1 second. I thought in a CD matter, you'd specifically asked, no? Okay.
I sure hope
Sorry,
not.
I had notification from my team. We offered to move cases from the 24th and the 31st, and we got some feedback that people did not want us to move one of the cases from the 31st and one from the 24th, so we kept them on. because if attorneys want to be here, we'll be glad to be here for you. That being said, okay, so never mind on the 31st. So if you do the math, right, your 14 days, you know where it gets you. It gets you coming here then. This court's fine putting it the first week in January, if that's what everybody wants and you need that time. If somebody wants me to do it the week so it's compliant with the 14 days, then we'll do that as well. What would y'all like?
I think we could attempt to submit the order within 14 days, and then if we need to have a hearing, if there's joint proposals that couldn't be resolved, if we had to come back, then we could do it the following week in January. I don't think any of us want to.
Clarify, just so I
Sure.
understand, especially what Mr. Turtzo is saying. You would either like an order within a certain, sure, I'm sorry, I'm not in front of my. Okay, let me just make sure I understand. You're either saying, get the order in within 14 days, or I can set a hearing. We can extend that 14 days. If you get an order into me resolving all these issues, then we're good? Or are we holding a decision in abeyance if we don't work something out? I guess I just need clarification there.
I wasn't saying you must get, I was asking you all what meets your needs in this case, is the open-ended question. This court's view is its oral pronouncement from the bench is its oral pronouncement from the bench. In the absence of you all coming to some agreement with regards to how to more clarify the definition of the clawback issue, this order is going to say the clawback issue, and then I will wait to see if I get any motion practice, right? And then see whether or not the parties have a viewpoint, whether that would fall within it or fall outside of it. I was trying to anticipate that and give you all a chance to get a little bit more clarity so that you're not arguing it down the road on a motion of whether it falls in or doesn't fall within, is to have you all get some clarity. I'm offering you that opportunity if you want it. If one side wants it, one side doesn't, then I'm going to have to use the term the clawback issue, right? And I'm going to refer to the papers that you all presented, right? And you all know what a clawback letter is, right? So it'd be anything that is a clawback letter would be subject to the carve out, okay? If there's a clawback letter, an issue regarding the clawback letter would be subject to coming before the court, and really would be the special master first pursuant to your agreement, unless you all stipulated that you wanted it to come to me directly. I'm trying to offer you options, and I'm also trying to offer you options with regards to the date in which it would happen, right? I am appreciative, 14 days from an order, right? Today being the 16th, I still think it's the 16th.
Is not ideal. 14 days from today is not ideal. Your
I'm
Honor, so-
appreciative of that, so I'm trying to offer you all the options, but if
Yes.
one side says, no, we want the 14 days because that's what the rule says. Then right, and there's not an agreement to extend it, I'm fine with you all extending it. But if one side does not want to extend it, then you can appreciate, I'm gonna have to say EDCR, right, 7.21. So I'm offering you all a lot of options if you want them. If you don't want them, then I'm gonna have to make a determination as to when the order from today needs to come in, which would be straight out of the rules.
Thank you, Your Honor. I think we would like more time than under the local rules for submission of the order, and we would ask the state.
In fact, we would propose January 9th as the date, if that meets with the state's agreement.
Which you can appreciate as you remember, this is an irreparable harm component, so I don't in any way want to have a longer term that somehow is not consistent with the concept of irreparable harm.
Right, we'd like the 5th. We think that kind of bridges the gap there.
Well, okay, the 5th is a Monday. It's not gonna be Monday. Well, I'm also supposed to be picking a trial on Monday, but
Well, we just want to, that's the deadline just to submit the order.
Right.
okay. You want the 5th and you want the 9th to submit the order. Is that
Yes, yes, Your Honor.
okay? Well,
But I mean, we'll if it resolves it, we'll agree to submit the order on.
okay, so the time period under EDCR 7.21 is extended to January 5th, subject to some joint request that I may or may not get between now and then, okay? Now, do you all want a hearing? Because what's happened in this case is I've gotten some competing orders, right? So someone who tries to anticipate things to minimize unintended consequences Do you just want me to see what I get by January 5th, right? And that would include if there is a competing order, which I'm in no way encouraging or discouraging, or even saying that they're all within the rules. I'm just a realist.
Okay.
And then the court evaluates if we need a hearing, or do you all want some additional hearing? The court's not requiring it, I'm asking.
From the state's perspective, a hearing the following week would be about at a 30-day status of the stay anyway. So I think it may be, from the state's perspective, helpful to put one on for,
Have a status conference right now for
That's what I was thinking.
January 20th.
You all had asked the court to vacate
Yeah,
the
that's been
January
vacated.
one.
Oh,
That's been
Remember,
vacated.
you asked the court to vacate
Yeah.
that, so the court did, so the next status check we show. Based on the party's request is not till February 24th, 2026. That's why I was mentioning a January date, given these new intervening facts that weren't available to the court at the time I received your stipulation to vacate the vacate the status check that was otherwise going to be set for January, so.
I think a status in mid-January would be helpful.
yes, Your Honor, we will be prepared to have status in January courts.
Okay. So you want the 13th, 15th, 20th, or 22nd? You're going for pretty much the middle, that means the 15th, even though it's a 31-day month.
20th I had booked already. It's still there. Or the 22nd.
Looks to me like you're probably wanting the 15th or the 22nd, right?
I'd like the 15th works for me. Does that work for the other? 15th would work for the state, Your Honor.
The 15th works for a minute.
Okay. So we'll re-put it on, since we had status checks anyway, we're now gonna just re-put on a status check, discuss outstanding issues. And we'll just do that on January 15th. And I am appreciative that we were gonna discuss that back in February, but now with the intervening circumstances, it makes sense. Parties agreement, we're gonna do that on January 15th at 8:30. Okay, is there anything else any party needs from the court at this juncture?
Not from the state, Your Honor.
Not from Meta.
Thank you so very much. Wish you all a great rest of your day, week, and happy holidays. If I don't see you between now and then.
Likewise, Your Honor.
Thank you.